was realizing and looking at the world and saying like, well, why is it that the only places where we can resolve a legal dispute in the US are the courts and then legacy arbitration forums, where we've all, as a society, just kind of accepted that, well, resolving a legal dispute at any one of these places simply automatically means it's probably going to be 18 to 36 months or more, right? And it's going to be a long drag, whether you're a company or an individual. Like that's just kind of the nature of lawsuits, right? And our thesis was, and of course, us being lawyers and seeing so many types of legal disputes come up, right, in employment, in corporate settings, standard contracts, consumer disputes. Our thesis was that, most legal disputes, the vast majority of them, don't need the long, drawn out, highly expensive, 3 year long process that we've all just kind of accepted, right? And frankly, relationships sour because of that. Like nobody goes through 2 to 3 years of litigation and fighting with each other in court or one of these legacy arbitration forums and ends up really staying friends.
Welcome to CRE Radio for influential commercial real estate professionals who work with investors, buyers, and sellers of commercial real estate coast to coast. Whether you're an investor, broker, lender, property manager, attorney, or accountant, we're here to learn from the experts.
Welcome to Commercial Real Estate Pro Network's CRE Radio. Thanks for joining us. My name is J. Darren Gross. This is the podcast focused on commercial real estate investment and risk management strategies. Weekly, we have conversations with commercial real estate investors and professionals who provide their experience and insight to help you grow your real estate portfolio. Today's interview is sponsored by Building Insurance and Risk. When you invest in real estate, it pays to work with a real estate investor protection specialist to protect yourself and your investment from catastrophic loss. The experts at Building Insurance and Risk focus on real estate investor protection. They provide you with multiple insurance coverage offers and a side-by-side coverage comparison. To learn more, go to buildinginsurancerisk.com. Today, my guest is Rich Lee. Rich Lee is a top lawyer, or was a top lawyer for two companies. And Rich Lee experienced the reality that dispute resolution today is driven by pain due to legacy dispute resolution forums and courts. Rich set out to change this with New Era Alternative Dispute Resolution, or ADR. And in just a minute, we're going to speak with Rich Lee about dispute resolution. But first, a quick reminder, if you like our show, CRE Radio, there are a couple things you can do to help us out. You can like, share, and subscribe. And as always, we encourage you to leave a comment. We love to hear from our listeners. Also, if you want to see how handsome our guests are, be sure to check out our YouTube channel. You can find us on YouTube at Commercial Real Estate Pro Network. And while you're there, please subscribe. With that, I want to welcome my guest, Rich Lee. Welcome to CRE Radio.
Thanks for having me, Darren. It's great to be here.
Well, I'm looking forward to our conversation. But before we get started, if you could take just a minute and share with the listeners a little bit about your background.
Yeah, my background, lawyer by training, engineering background, and then lawyer by training. Before I'm still a licensed attorney. Grew up in corporate and intellectual property law. Been a lawyer for 18 years. The 11 years before I launched New Era, I was with two different technology companies, both venture-backed technology companies. Joined early stage, grew them both, to pretty substantial companies. Before leaving to launch New Era with a few of my co-founders, who I also met through the tech world, and who are also, former lawyers. Well,
that's quite a background there. So you were trained as an engineer and an attorney?
Yeah, so I was a bioengineer, and then decided that, the law has always fascinated me. Decided that I wanted to become a patent lawyer, so I could see kind of the newest innovations all the time. So I went to law school, became a patent lawyer, but quickly realized that writing patents, I wanted to see the newest phones. I didn't want to be patenting the 10,000 components inside the phone. So quickly realized that, while a very great career, not really something for me. Um, so then, I actually led market development, so almost like a sales type role. Led market development at an IP investment bank where I was brokering a lot of buy side and sell side technology transactions. Led market development in Asia, I should have said, primarily in Taiwan and Hong Kong. So sell side helping, a lot of kind of incumbent US tech companies, divest a lot of non-core technology assets. And on the buy side, helping a lot of these like emerging and now actually household names in Asia, buy up a lot of technology assets. And then of course that led me to, the 11 years across the two tech companies where, I really was able to get really, really close to the tech, right? And help with go to market, help um, with product, and of course, legal and overall, fundraising, because we raised a lot of venture funding at both companies. And so definitely a non-traditional path for a lawyer, but honestly, I wouldn't have it any other way.
No, I would guess that your background and kind of your experiences gives you kind of a unique edge for what you were doing there, and having that both sides of the understanding there as opposed to just the one side. So that's interesting.
Absolutely.
Um, yeah. So I guess I'm kind of curious. In what you described there, I guess with patents, I could see a lot of disputes. What led you to this dispute resolution um, change here? There, the new era.
Yeah, a lot, right? And legal disputes, you certainly don't need to be a lawyer at all to understand that, resolving a legal dispute in the US is painful, expensive, distracting. And I experienced that firsthand, especially when I was inside these companies. And of course, for the purposes of this podcast too, right? In investments, you're going to have partnerships, you're going to have, investment docs, the actual assets themselves, the real estate assets, right? A lot of legal disputes come up um, in all of these different settings, right? And so we'll come back to that. But for me, the why was, you know, and my co-founders was realizing and looking at the world and saying like, well, why is it that, the only places where we can resolve a legal dispute in the US are the courts and then legacy arbitration forums, where we've all as a society just kind of accepted that, well, resolving a legal dispute at any one of these places simply automatically means it's probably going to be 18 to 36 months or more, right? And it's going to be a long drag, whether you're a company or an individual. Like that's just kind of the nature of lawsuits, right? And our thesis was, and of course, us being lawyers and seeing so many types of legal disputes come up, right, in employment, in corporate settings, standard contracts, consumer disputes. Our thesis was that, most legal disputes, the vast majority of them, don't need the long, drawn out, highly expensive, 3 year long process that we've all just kind of accepted, right? And frankly, relationships sour because of that. Like nobody goes through 2 to 3 years of litigation and fighting with each other in court or one of these legacy arbitration forums and ends up really staying friends, right? And so our premise was most legal disputes don't need that, right? Certainly you have a top layer, a very thin layer at the top of, think actually patent disputes, um, highly complex, multi-billion dollar, real estate developments gone wrong or whatever that probably should go to court, right? But the everything else around, partnership agreements, employee agreements, standard kind of investment documents, you know, contracts with vendors, contracts with suppliers, like all this stuff, all these give rise to disputes. But our premise was like, yeah, but when these disputes come up, frankly, what we've seen um, in all of our experience is that both sides actually don't really want to fight. They just want a resolution. And so what we currently do, to kind of achieve that want a resolution desire is we kind of acquiesce, right? One side either never brings their claim, even though they've been wronged, right? And they might just sit and be like, well, if I try and fight this, it's going to take 3 years and it's not worth my time. Or on the other side, sometimes companies or individuals, they might get hit with, frankly, like a BS lawsuit, right? And but what do? They settle them. They don't settle them because they did anything wrong. They settle them and pay just some amount, right? Because while the other side of not settling is 3 years of time, 2 years of time, and all that expense. And again, it's not worth it. But if you think about that, that's actually fundamentally wrong, right? You're either walking away from protecting yourself or you're paying something to not protect yourself, simply because you're avoiding pain. And so for us, the premise was, let's finally create that alternative place to resolve legal disputes that we wished we would have had, right? And so that's what New Era is we're still arbitration. So think of us as still like an alternative digital court, right? So we are the neutral place where two sides come and have a neutral arbitrator or mediator help resolve that dispute. But things get done in 100 days on our platform versus the 2 to 3 years. It's all for one flat fee versus like a lot of the hourly and, never ending expenses and time that are kind of just like synonymous with a lot of the legacy places, right? And then, of course, and I think I mentioned everything's done virtually, right? And so, we all come from the tech world. And so our premise was, you know what, all of this can be done, especially with the advent of Zoom. Nobody needs to be taking time out of their day to just go somewhere physically in person when this can be done just as well. But then more importantly, as we built it, even though it's 90% faster and more efficient, still making sure that the same quality people who are deciding the cases, in the old places are the same people doing it here, right? But just under our rules and on our platform. And so even though it's far 90% faster and cheaper, it's the same quality people, same experienced people hearing your case, right? So for instance, a real estate dispute, you will have real estate professionals or former real estate lawyers or judges who are deciding these disputes and not somebody who comes from, crypto or something. Um, and so that's the nature of New Era. And we built it, launched it a few years ago. Unfortunately, the markets reacted, the way we expected, which is we knew that there was a huge need for this. And so we have clients ranging from, sports organizations like national sports organizations like the US Olympics to large entertainment companies, to actually a lot of large real estate brokerages, you know, um, large retail organizations, two of the biggest automakers, some of the biggest banks in the country, you name it, right? Everybody has their pockets of legal disputes where they're like, finally, right? Finally, there's a place where we can resolve these based on what actually happened and get it done fast. And then more importantly, maintain a relationship after that dispute, right? Because when you kind of resolve something in about 100 days, there's very little time for games, first of all. And then when there are no games being played, people generally, there's kind of it's kind of cathartic, right? To just be able to be heard, present your case in court, in quote unquote court, um, and then have somebody make a call, right? And then but afterwards, once it's put to bed, right, the two sides can maintain their relationship, right? And so, I know like kind of before this call, we were briefly talking about this, but in the real estate investment world and real estate world in general, relationships are everything, right? And so our thesis for, society as a whole is that, hey, when you resolve things far faster, frankly, more disputes should get heard and frankly be filed and, and going through the system. But that's good because then everybody has the release. It's done in 100 days, and relationships are way better off for it.
Yeah, I love everything you're saying about the speed and efficiency of the system. My question to you is, so how is it that this can be a solution? Does it need to be written into the contract, or is it any kind of a mediation that can be brought to New Era, or can you bring any litigation to New Era?
All of the above. Right. So, okay. So real quick, mediations versus arbitrations, right? The key difference there is simply that mediations, it's the person in the middle, the neutral third party helping the two sides is simply trying to help the two sides get to some sort of compromise and middle ground, right? The results of a mediation could still be the two sides walking away, Or if they do have a meeting of the minds, then, then they'll have a mediation like settlement agreement, right? So mediations are a little less committal. Arbitrations, more like what we're used to in court. There's a winner and a loser, and the neutral third party in the middle is calling balls and strikes and ultimately saying so and so wins, so and so loses, so and so pay the other person. So quickly, that's the nature of the two things. We do both. Um, and so going back to your question, yes, the most common way, for example, like the way all these organizations that I just kind of rattled off adopted us is through contract, right? So at the end of every contract you've ever signed, any investment agreement you've ever signed, or terms of use you've ever clicked through, at the end of every contract, there's always a clause that says, if we have a legal dispute under this agreement, we will resolve it in the courts in New York, or, the courts in Oregon, or, this arbitration forum. People are crossing that out and putting in new era ADR. And by virtue of just that simple free act alone, just by changing contracts, that ensures that any future agreement, right, not only comes to us, but because it's coming to us, that any future disagreement under that contract is going to be done in about 100 days versus the really long, painful process, right? And it fundamentally kind of changes the way you approach that case. And so that's generally for arbitrations. But, mediations, absolutely. We have a lot of organizations, like two sides just coming to us for mediations. Um, the general overarching rule is it just takes both sides to mutually agree, right? So from an arbitration standpoint too, even if a contract said court, theoretically the two sides could still come to us, right? But both sides have to agree. The only thing I would say to that though is that, human nature is that once two sides are already in disagreement and at odds with each other and probably ready to go file a lawsuit, the last thing they're going to do is agree to something new that the other side proposes, even though it would benefit both sides. Because naturally there's a distrust. You think there's something in it for the other side. And so that's why I generally say, people put it in contracts. So templates, employment agreement templates, employee handbooks, investment agreement templates, property management agreement templates, landlord tenant, right? All these things, all those agreements can be changed, right? To put, to kind of choose, right, where you want to go to resolve your legal dispute.
So I hear all of the pros, meaning everybody that I mean the time savings. If you've ever been involved in a lawsuit and um, I know clients of mine, I mean it can take years out of your
Yep.
life, uh, and just the stress of that on top of trying to run your business, and then having to whether it be go to court or meet with the attorney or depositions or whatever that is that it takes all that time to put the story together, um, versus 100 day. I mean, I see that being totally appealing.
Hmm.
Um, I guess my question is, where have you seen the resistance?
The resistance is, one is for, folks who forget to bifurcate or forget that you can send certain disputes here while other disputes go there, right? And so sometimes people will just automatically go to like, well, what if that new development just completely collapses and it's catastrophic and I can't have that being done in 100 days. And my answer is then don't, right? For those development agreements and those construction agreements, you should put in court so that way, when God forbid something comes up, you are turning over every stone and and really exploring every nook and cranny in terms of your arguments, because that's important, right? But for everything else, the contractors who are coming on, even some of the investment docs, the financing docs, and a lot of like the kind of run the business type, litigation, those contracts you should send to us, because those are things you don't want to be, getting stuck in for 2 to 3 years. But you also, here's the important part, is you also don't want to be acquiescing, right? And almost like being strong armed into like some sort of result that you didn't want to be in, simply because, you know, standing up for yourself meant 2 to 3 years of your time. So that's one area of resistance. The other is, that like, and now far less of it. When we first launched, just kind of typical with lawyers, and I am one, so I know like lawyers are risk averse, right? And so sometimes when something's new, even though innately they know that it's a really good idea and they say like this makes way too much sense, sometimes they need a little just social proof, right? They need to know that other people are doing it first before they kind of jump in. And so fortunately for us, right, we're well past that point in terms of, when somebody asks us like, well, who else has vetted it? Who else is using you all? We can rattle off a number of, organizations and law firms and their law firms who vetted us, went through our rules, went through our platform, gave it a thumbs up, and then put it in all of their agreements. And then lastly, I would say, honestly, if if a company or an individual's MO is that they want to, the way they approach a dispute is to just strong arm the other side, play games, be, not just deal with it directly and civilly, but they just want to bury the other side, well, then we're just not for you, right? Because it's right there on our website that like it's ending gamesmanship. That's the goal, right? A lot of these other legacy places they have a long set of rules and procedures that allow people to play games right within those rules. And so for us, without getting too deep into our rule set, we have a lot of levers, financial levers, technology levers, and then our rules and procedures that really clamp down on the ability for either side to play games. And then if they try, empower the neutral third party to just shut it down in a way that like even a judge in court couldn't just shut it down. And so there are some organizations like that, right? And we all probably can name a couple off the top of our heads who, they do something wrong, somebody comes after them, their approach isn't like, well, let me make this right. Instead, it's I'm just going to be really, really difficult and, make this really hard on the other side. Um, because that's their MO.
So I'm not an attorney. I'm just kind of, watch the courtroom on TV kind of stuff. So if somebody comes to you, it gets resolved. That seems like a pretty straightforward thing. What if the conclusion is we can't agree, or is there any appeal? Or or does it have to be written into the agreement that this is the arbiter of, or I mean, this is the final stop?
Yep. So in mediation, certainly there is that component. You can choose to not agree, and then the mediation wasn't successful, right? So as I said earlier, the mediations are less committal. Um, if they do agree, then the two sides will basically enter into a settlement agreement that their lawyers will draft for them and they'll sign, right? So that's mediations. In arbitrations, there really isn't a component of somebody not agreeing because you've already pre-agreed to come to arbitration, right? Whether it's through a contract or the two sides saying, sure, let's do our case here instead of in court. And so by definition, you've agreed that what the arbitrator decides at the end, and they will have a winner and a loser, right, is the final judgment. And so arbitration, it's governed by federal law, the Federal Arbitration Act. Generally, no rights of appeal, right? Arbitrations are pretty final, but of course, the trade-off is that it's supposed to be much more efficient and much more cost-effective. It's just that over time, it evolved into this behemoth where it was not efficient and it wasn't cost-effective. So part of what we're doing is, bringing it back to what it was always intended to be. And so, yeah, at the end of it, someone will be a winner and a loser. And then just to kind of connect the dots fully, right? If let's say somebody said, Rich, pay Darren X, and then I refuse to, you can then take that arbitration award to court and say, hey, judge, I have this arbitration award. And then because of the Federal Arbitration Act and federal law, judges will recognize that and then take your award and give you a court order, right? Which says, Rich, now the court's ordering you to honor this arbitration award. And if I don't do that, well, then that's criminal contempt. And, and so that's how everything kind of works all the way to the end.
Got it. Got it. I appreciate you taking us through that.
Mhm.
So I guess the ideal is that this is in the contract up front, so everybody knows this is the place to resolve any disputes. If it's not in the contract, you got to get agreement from both parties that will use this rather than going through the other process or the traditional process. Is that right?
Mhm. That's right.
Got it. Got it. And being that you're virtual, um, do you have third party? I mean, are these I presume attorneys or mediators that are just on staff or that are available or independent that you connect? Are you guys more of the platform that connects all the parties? Is that
Exactly. We're the platform that connects them all. Think of us as, almost like Uber, right?
okay?
For arbitrations and mediations. And, the driver, the analogy to drivers is the arbitrators and mediators. They're all over the
Gotcha.
country. Um, retired judges, retired lawyers, currently practicing lawyers. We make sure that people are minimum like 15 years experience into their kind of law practices so that, just to ensure that these are all very knowledgeable people who are hearing the cases.
Yeah, I see this as being a huge shift, paradigm shift, as far as a way to, uh, you know, to efficiently get through challenges. The
Yep.
disputes. Makes a lot of sense. A lot of sense. And how long have you
Yeah.
guys been doing this?
So we're coming up on 4 years since our official launch. We were kind of working on it for about a year and a half before we launched, just to kind of perfect the platform, perfect the rules, raise venture capital. So we're VC backed. So we raised an initial round of funding before we launched, but about 4 years in.
And as far as the fees you guys generate, are those? Uh, I mean, if you have a dispute, you know sign up and you get the you said the flat fee was kind of identified up front. Is that right?
Yep.
100
So
days of flat fee.
we have a fee schedule on our website. It's there's different tiers kind of based on the different levels of complexity of a case, right? So anywhere from, $3,000 typically split between the two sides, so about 1,500 a side, to $5,000, so 2,500 a side, or like $10,000, 5,000 a side. And that's all in, right? It includes
Oh.
the arbitrator fees, the mediator fees. The only thing it doesn't include is if you bring your own attorney, of course, you're going to pay your attorney separately. Um, but we're not the law firm anyways, right? And so that's if you the benchmark for that though is $50 to $100,000, right? At traditional arbitration forums, and then because of time, the amount of time those disputes take, just the additional amounts of attorney's fees you're going to have to pay to your lawyers, that's how we get to like very quickly, 90% savings, right, to any other forum. And I think that's worth, kind of just drilling into real quick, which is, one of the things we've seen, both when we were in-house, when we were still practicing law, and of course now, is that this is that often overlooked thing, right, to business folks when they're doing deals and they're entering into relationships is certainly everything up front is, it's the honeymoon phase, right? And when you're looking at the agreement, a lot of people never, most people don't look at that clause at the very end because, and rightfully so, I was guilty of that before because the traditional things you could put in, places you could choose to resolve your legal disputes, right? The courts or traditional, like these legacy arbitration forums, they were all pretty inefficient, all very expensive, all time consuming. And so, of course, you're going to spend your time elsewhere, in your agreements, whether it's an investor agreement or some employee agreement or whatever. And so the reminder for us that we mentioned to all business, folks, who aren't the lawyers thinking about these things day in and day out is that, hey, this is actually a clause that can, this little change, this little line in your agreement, in any agreement, is literally the difference now between, you know, spending 100 days, and quickly resolving a legal dispute and hopefully preserving that relationship afterwards, or spending 2 to 3 years souring a relationship and having this thing hanging over your head. And so, not so much a plug for New Era, but just a reminder that like that's something worth looking at, right? When you're entering into any sort of agreement, even if you're not a lawyer, or at least asking your lawyer, like, hey, what are the implications of this? Um, because this is the thing that, like, God forbid something happens, um, and there's a disagreement. This will start playing a role in how you approach that even the case before anything goes to court or arbitration, right? As you're looking at this and you're saying, well, I think I'm owed 100K, but if if like going and trying to collect that 100K means 2 to 3 years of your time, you may just walk away and eat it, right? Which is wrong. But then if it's 100 days, now you're going to go after it, right? And so it really kind of moves upstream and affects decision making, right, well before anything's ever even filed. And so it's just a reminder that, like, we've written about this as a company, that like that is one of the most impactful clauses of an agreement that nobody ever pays attention to. And so, something worth paying attention to.
Got it. Hey, Rich, if we could, I'd like to shift gears here for a second. By day, I'm an insurance broker, and as such, I work with my clients to assess risk and determine what to do with the risk. And there's three strategies we typically consider. We first look to see if there's a way we can avoid the risk. That's not an option. We look to see if there's a way we can minimize the risk. And if we cannot avoid nor minimize the risk, we look to see if there's a way we can transfer the risk. And as such, I like to ask my guests if they can look at their own situation. Could be your clients, your investors, the
Mhm.
traditional way of doing business, whatever it is that you identify and consider to be the biggest risk. And again, for clarification, while I am an insurance broker, I'm not necessarily looking for an insurance related answer. And so if you're willing, I'd like to ask you, Rich Lee, what is the biggest risk?
I'll answer that kind of in like two parts really quickly, right? The first is, I think, in the real estate industry, and actually in business in general, I think the biggest risk, in a lot of just kind of business dealings is the relationship, right? And maintaining good relationships, whether it's with an existing, counterparty, or, a future counterparty, or a former counterparty. Relationships are everything. Um, and so all the things you do, right, to mitigate that, both before and then of course, during a relationship, and then God forbid, if something sours in that relationship, I think that's, it's critical, and something that I think is often overlooked. For us as a business, right, the thing that I will think about all the time and that we obsess about is, frankly, and it's still related to the relationship, it's the user experience, both on the platform, on our actual technology platform, but also just the experience overall. And the experience for all the people that would be involved in a dispute on our platform, which is both, the plaintiff, the defendant, the two sides who are actually in a disagreement, their lawyers, right? So that's two more parties, and then the arbitrators and mediators themselves, and their experience, administering and adjudicating a case on our platform. And so it's something that we obsess over a lot, in terms of, you know, both the people we hire, finding the best people who are smart, biased towards action, empathetic, right? So even your interactions with us are positive. And of course, every product we design, every feature we add, every additional process we create, even every new rule or any rule change we make, right, to our arbitration rules, always with that kind of end user in mind, and like what the experience is going to be, and of course, fairness above all else.
Yeah. No, it's awesome. And I love hearing about your product and how you guys are going about it. And I just think the opportunities are wide open as far as people adopting it and this becoming kind of the new standard. It just makes a lot of sense for anybody that's ever been through something like this. I can't imagine there'd be a lot of pushback. So that's
Yeah,
good.
thank you. Yeah,
Yeah.
we think so too.
Yeah. Hey, Rich, where can the listeners go if they'd like to learn more or connect with you?
Go to our website, www.neweradr.com, or always, feel free to drop me a line. Love hearing from folks. It's just rich.lee, Lee, at neweradr.com.
Got it. Well, Rich Lee, I cannot say thanks enough for taking the time to talk today. I've enjoyed it, learned a lot, and look forward to doing it again soon.
Thanks for having me, Darren. This was fun.
All right. For our listeners, if you like this episode, don't forget to like, share, and subscribe. Remember, the more you know, the more you grow. That's all we've got this week. Until next time, thanks for listening to Commercial Real Estate Pro Network's CREPN Radio.
You're listening to CREPN Radio for influential commercial real estate professionals. For more information on this or any of our guests, like us on Facebook, CREPN Radio.